Good afternoon. Welcome to this talk organized by the Center for Comparative and Public Law. I'm Cora Chan, Associate Professor of Law, and I'll be chairing this event. Today, we're very honored to have Dr. Alain Zet, Senior Lecturer in Public Law at the School of Law, University of Glasgow, to speak to us. Dr. Zet's research looks at the practice of regional and international courts from the perspective of legal and political theory. He is the author of the ECtHR and Human Rights Theory, published with Routledge in 2017, and is currently completing a monograph entitled Calibrating the Response to Populism at the European Court of Human Rights, which is forthcoming with Cambridge University Press in 2024. I'm very much looking forward to reading the book. Dr. Zet has published widely in distinguished journals such as the International Journal of Constitutional Law, Human Rights Law Review, Global Constitutionalism, Racial Jurist, Criminal Law and Philosophy, and Canadian Journal of Law and Jurisprudence. We are delighted that he's currently a visiting fellow with the CCPL until the end of February. Very welcome to the Center. Today, he will speak to us on the rule of law backsliding and the response by European courts, in particular the ECtHR and the CJEU. So Dr. Zet, welcome, and the floor is yours.
Well, thank you very much, Cora, and thanks everyone for coming. I'm very delighted to be here. What I want to do in this presentation is to give you an overview of what has been called rule of law backsliding in recent years in Europe. I've chosen rule of law backsliding, but I could have chosen another concept, another word that has been used. So there's a flurry of descriptors that have been used recently to describe a particular phenomenon in Europe. You have rule of law backsliding, you have abusive constitutionalism, you have democracy decay, you have constitutional rot. All these concepts seem to talk about the same things. And sometimes scholars are very quick to make these kind of evaluative and critical statements about a particular phenomenon. What I want to do in this presentation is to go back to the phenomenon itself. And so the first step will be to look at the phenomenon itself in 3 European jurisdictions. I'll try to give you a little bit of context about each of them to get you started. Hungary, Poland, and the UK. And then I want to discuss how these phenomena have been qualified. So what I want to do is to give you a few tools with which we can analyze and evaluate what is currently happening in Europe. And finally, I want to essentially survey a few decisions by European courts. And by European courts, I mean the European Court of Human Rights on the one hand, and the Court of Justice of the European Union on the other. The difference between the two essentially is that the European Court of Human Rights is a specialist court. It adjudicates over the European Convention on Human Rights. It has the final say about the interpretation of the convention, whereas the Court of Justice of the EU, being the final judicial organ of the European Union, is also tied to the broader goals of the European Union as promoting political and economic integration. Okay. With respect to these decisions, I will look at 3 issues that seem to speak to the phenomenon of rule of law backsliding. We have to see the extent to which these courts have actually tackled these issues and how. One will be journalistic freedom, and we look at Hungary for that matter, judicial independence with respect to Poland, and immigration legislation with respect to the UK. Journalistic freedom is not only an issue in Hungary, it is also very much an issue in other European states, and Poland is a prime example. Same thing for judicial independence. We'll zoom in on Poland, but Hungary is concerned with essentially the same structural problems. Okay, so this presentation will be a lot of snapshots And if you'd like to discuss this or that issue or context in more depth, please ask me during the Q&A. Okay, so what has been going on in Europe over the last 10 to 15 years? I like to start with associating legal phenomena with specific government and specific legislation. So what we call rule of law backsliding has been developing in the context of the establishment of 3 governments that are still in power today. So on the left-hand side, left-hand side is the Prime Minister of Hungary, Viktor Orban. Viktor Orban has been benefiting from a large 2/3 majority in Hungary, which has helped him essentially strengthen executive power over the other branches of government. We'll see that in more detail. In the middle, you have the president of Poland, still in place, Andrzej Duda. I mention him specifically as president because the prime minister of Poland recently changed. In the last month, there's been a lot of changes at the top of the Polish government, and that also concerns the media and the judiciary. Okay, so a very evolving situation. On the right-hand side, the current Prime Minister of the UK, Rishi Sunak. I'm going to talk about immigration legislation in connection to Sunak's government, but you might be aware that this, I would say, strengthening of or this reshuffling of immigration legislation goes back to Prime Minister Boris Johnson, who was imposed right before that. Okay, so I don't want to say that these are the architects of democratic or rural backsliding. I just want to say that these can be associated with the phenomenon broadly speaking. All right. Having said that, is it okay with the mic? Because I feel that I could, yeah. So I will just speak, I think. And can you all hear me? Yeah, okay, great. So now that we have an idea of the phenomena that has been described as rule of law backsliding, which is the attack on the independence of the media. So when we talk about attacking the media, we have in mind, for example, very violent and coercive actions on the part of the state, actions that you observe, for example, in Russia or in Turkey. Both are members of the Council of Europe and signatory of the European Convention on Human Rights, that I will talk about later. So we have in mind basically governments arresting journalists, intimidating journalists, and they often do that by resorting to the criminal law, accusing journalists of serious criminal offenses. That's not how the Hungarian government has been operating. The Hungarian government has been operating very much in a structural fashion by controlling, monitoring, and oversight bodies. What I mean by that, 2 institutions, the National Media Authority and the Media Service Support and Asset Management Fund for what concerns public media. And also with respect to private media, there has been a huge concentration of entities being put under a single corporation, essentially. And the people in charge of that corporation are very close to political power and especially to the prime minister. So what we observe is essentially controlling not journalists individually, but controlling the conditions in which journalists work, the condition in which they can, for example, appeal decisions, the conditions in which journalists are fined, all these kind of conditions that are relevant to their work, that is basically the object of control by the Orban government. Okay. So a control that is, again, not coercive and individualistic, but structural. You control the structure, and then you create a chilling effect on journalism. The judiciary has known a similar process of control. The word that has been used with respect to the judiciary is court packing. So the idea here is that instead of having the oversight and monetary bodies being appointed or being controlled by peers, it is controlled by the parliament. Okay. So all of a sudden you have a break of the separation of powers. These bodies are not independent anymore. They are basically controlled by a combination between the parliament and the executive. Okay, so that's a clear, if you want to start understanding and evaluating the phenomenon, clear break of the principle of the separation of power. And what's interesting about the kind of control that is exercised in Poland, but also in Hungary, is that these governments do not only control existing bodies, but they also create new bodies. And they often say that these bodies pursue a very virtuous mission, such as maintaining the independence or the diversity of an institution. But in fact, in operation, they do exactly the opposite. So here again, controlling the judiciary has been very much structural. It's not about, I just read recently a book about the Philippines where judges are individually attacked, intimidated. It's not of that kind. It is a structural attack. And I think that sort of gives you an idea of their mode of functioning. Now, what I've said so far about Hungary and Poland does not apply to the UK. In the UK, if we want to talk about democratic or rule of law backsliding, we have to look at specific pieces of legislation. Courts are still very much independent and strong. The media is still very much alive. But with respect to a particular issue, which is immigration, and in particular, you might have heard about an increase of the number of asylum seekers that, for most of them, cross the English Channel to seek refuge in the UK. And they do that on small boats, most coming from France and crossing the Channel to the UK and basically make an application for asylum in the UK. And recently, the Conservative government has been extremely active and forceful in trying to stop, by any means possible, the crossing of the Channel. And it has done that by essentially outsourcing the processing of asylum applications to Rwanda. Okay, so in the UK, all that work is outsourced to Rwanda. Now, what's really interesting from the perspective of rule of law and democratic backsliding is that usually, and that's perhaps a broader point about human rights in the UK, whenever there's a proposal of legislation in the UK Parliament, the minister in charge of the bill has to state that the bill is compliant with the European Convention on Human Rights. Okay, that has been the case since the implementation of the Human Rights Act in the UK in 1998. Now, what's really interesting in the context of the Rwanda bill is that the minister explicitly said that he cannot, or it was a he, I think, cannot guarantee
the compliance with the European Convention on Human Rights. So you can see that there's now a tension between the UK legal order and in its relationship with the European Convention on Human Rights. And that's a tension that has been ongoing for some time, I would say at least since the famous Hearst judgment, which concerned the right to vote of convicted felons in the UK. So there's a bit of a strained relationship there, and things are not really improving. One of the contentions in this respect is also about how and why Rwanda is not considered a safe country by British courts. So unlike Hungary and Poland, we still have independent courts in the UK that have explicitly said that asylum seekers cannot be sent to Rwanda because there's a fear that their basic human rights will be violated while having their application processed. The risk here is what in international law we call non-refoulement. So non-refoulement is the principle according to which if there's a risk that your basic human rights will be breached by returning the applicant to his or her country of origin, then there should be a clear prevention of that happening. So again, in the UK, this is more specific. It's really about the theme of immigration. It's about the tools that the government has in tackling the problem. It's not a structural issue, I would say. But still, as I said, it's a serious concern with respect to human rights and the rule of law. I will say a bit more on that later. So I've tried to be very descriptive in giving you this overview of these three jurisdictions. Now I want to move to a more critical discussion of what has been happening and how can we best describe and understand these phenomena. So I've already said that with respect, for example, to judicial independence in Poland, it's a clear break of the separation of powers. This is something that has been said both by the European Court of Human Rights and the Court of Justice of the EU. You have now a flurry of judgment saying that. But is that the only thing that has been happening? How can we expand a little bit our analytical lens to understand what's going on? So one of the concepts that I find really useful in qualifying this phenomenon is what has been called self-authoritarianism. That's exactly what I was trying to describe earlier, which is this idea that an authoritarian government might resort to physical violence and coercion and intimidation, but can also try to reduce the cost of intervening so that what it does doesn't attract international criticism. Okay, so trying to lower the cost associated with authoritarian practices. I think that is a useful concept in reflecting on what has been going on in Hungary and Poland. I should say that in contrast to other authoritarian contexts where elections are not necessarily fair, in Hungary and Poland, there's been no problem about that. There's been very, very minor issues, but otherwise, these governments really benefit from electoral legitimacy. Okay. So that actually leads me to the other concept that I would talk about later, which is populism. So populism is this idea that there's a strict distinction between the people, the real people on the one hand, and the corrupt elite on the other hand. And what this government has been trying to do is to say, well, the will of the people have spoken through elections, and now we have to sort of get rid of all these elites. And these elites could be the judiciary, they could be the media, and that's why you have an attempt to clean these institutions through structural capture, essentially. Okay, so populism, I think, is different from authoritarianism in that respect, because authoritarianism doesn't necessarily involve maintaining a very fair process of elections, right? Whereas populist practices, I think, can and have. So populism as antagonistic politics between the real people and the corrupt elite, I think that's a helpful analytical lens to understand what has happened. If you want to look at what democratic theorists have said about populism and how their concepts can be useful in understanding the phenomena I've been talking about, there's this idea in the theory of democratic representation that democratic representation should not, if you want, should still kind of continue the process of deliberating between the different voices and different views. Okay, deliberation, democratic representation through the electoral process is necessary and important, but the process of the democratic process of deliberation doesn't stop with the electoral verdict. Under populist rule, democratic theorists are saying representation moves from pluralism to embodiment in a single person. And that's why these populist regimes are often associated with a single leader, such as Viktor Orban in Hungary. You can also, to some extent, talk about Boris Johnson in the UK. So it's a strategy, as Nadia Urbinati says, it's a strategy for embodying to hold people under a leader rather than regulating the political dialectics amongst its plural claims and advocacies. Okay, so democratic theory can also here give you a lens through which to think about these developments, specifically the populist ones. Now, with respect to the judiciary in Poland, as I said earlier, it's pretty easy to say the sense in which judicial independence has been compromised. And again, both the European Court of Human Rights and the Court of Justice of the EU have said that very clearly. The European Court of Human Rights has said that relying on Article 6 of the European Convention, which is basically the right to a fair trial. And the CJEU has been referring to some basic provisions of its treaties to say that essentially the same thing. But is that everything that we can say in terms of constitutional theory about what has been happening in Poland, for example, or in Hungary for that matter? So constitutional theorists have suggested that if we were to offer the best rational reconstruction of what's happening in these constitutional orders, we could look at the principle of constituent power. So the idea of constituent power is basically the one that political and legal authority ultimately lie with the people. So you can see how populism and constituent power have some interesting interrelations. But of course, constitutionalism as a broader conceptual framework also includes the idea that political power is limited and that the constitution offers the terms by which a community discusses and mediates. The populist constitutionalists do not want to have that. They want to, as I say, as I referred to Koyas and Boker, the constitution is essentially instrumental to guarantee the existence and the survival of an homogeneous people. Okay, so you can see how the very idea of a constitution and constitutionalism is being twisted. So here again, this is just a snapshot. There is a lot more concepts and approaches that we can use to better understand what has happened. But I think that constitutional theory on the one hand, the democratic theory are very helpful lenses to better grasp what's happening and to offer some kind of conceptual framework. Okay, moving on to the UK. So as I said earlier, we don't observe in the UK a process of packing regulatory oversight and judicial institutions. So it's very important to keep a distinction here. But again, with respect to immigration and the ways in which immigration situation claims have been judicially reviewed, we can see that there's still a slight risk posed to the rule of law and some rule of law principles by the government. The courts have been very protective of those, but by the government. So one of these basic rule of law principle is that you can expect from a government a measure of self-restraint, especially when it comes to potentially breaching international law. So as I said earlier, with respect to the European Convention on Human Rights potentially being disrespected, the idea is that you can expect a liberal democratic government to make sure that it complies. The UK government, I think, has moved to this populist, I would say, to this populist sphere in which it is ready to risk or sometimes blatantly violate international law in the name of the will of the people. Okay, so that's relevant with respect to Brexit, but that's very relevant with respect to asylum seekers seeking refuge in the UK. I will just mention in passing that the HM case recently in the UK is an interesting case in which the Home Office has had to disclose and deliver some information to the lawyers defending asylum seekers in the process of judicial review. And it's one of the first instances in which the Home Office has actually not disclosed that this kind of relevant information. So the idea here is that we see an kind of a slight attack on the rule of law in the sense of transparency in judicial review. But again, these phenomena are a lot more specific and circumscribed. Okay, so it's not the scale that we've observed in Hungary or Poland. Okay, so now, again, my idea with this presentation was to give you a kind of a descriptive account of what has been happening, and then to give you some tools and some conceptual framework to think and reflect about these phenomena. Now I want to move to some select judgments in which we can see these phenomena being tackled by courts and the tools that have been used by courts to address them. So I'm going to talk a little bit about journalistic freedom in the case of Hungary. So here what's interesting is that while the attack on the media, as I said, remains largely structural in Hungary, you can still see some measures taken by the official services of government in Hungary that have a very individualistic impact. What I mean by that is, for example, in the case of Manley against Hungary, that's a case against before the European Court of Human Rights. Some journalists wanted to interview politicians about a potential scandal of corruption in government. The thing is that they conducted these interviews outside of the areas in parliament, in the Hungarian parliament, that are designated for such purposes. So you might think that's a minor breach and that could be accommodated. Yet the Hungarian government has been very strong in prohibiting and imposing large fines on these journalists. So these are the kinds of cases that have reached the European Court of Human Rights. And you can see that, therefore, the court doesn't have necessarily a grasp on the structural attack on the media. And that's because the European Court of Human Rights only has jurisdiction with respect to individual rights, the individual rights protected by the European Convention. So the best that it can do, for example, in the case of journalists in Parliament, is to require that there's a better procedure for imposing fine by these journalists. So typically, the European Court of Human Rights has requested that authorities give reasons when they impose fines. These kinds of procedural safeguards that can help a journalistic freedom. But again, it's very surgical, it's very specific. And so far, the European Court of Human Rights has not had a chance to review the entire framework for monitoring the media. So there's a limitation, a very strong limitation to what it can do. With respect to Poland and the judicial independence issue, it's a very long saga and chapter. So I'm going to try to be very brief and concise. Essentially, the main event is that for the first time, the EU Commission in 2017 started infringement procedures against Poland for failing to abide by rule of law standards with respect to judicial independence. Poland did not comply, and for the first time, a financial penalty has been imposed on the government of Poland. We're talking about 1 million euros a day. So an extremely high penalty that shows that the Commission has been taking the issue very seriously. The Court of Justice of the EU has also been contributing to that effort. But in these two quotes, there's something happening. So this is the case. These are passages of the case in which the government of Poland essentially contested the sanctions, the financial sanctions imposed against Poland. And the interesting is that the Polish government is essentially engaging with the very concept of the rule of law. So you could think that it's the courts that are going to engage with the rule of law, but actually you see governments very much trying to twist rule of law concepts. And here, the argument of the Polish government is to say that the Commission has abused its discretion and it does not guarantee legal certainty as a very basic standard that you find in the thin accounts of the rule of law. The court has showed deference to the Commission and to the discretion that the law gives the Commission in that respect. But this is an interesting phenomenon, right, by which governments are essentially trying to remodel and redefine the concept of the law. As you can see, they talk about the lack of a universal definition, so relativizing essentially the rule of law to further their interest. Okay, if you want to talk more about the CJEU saga, please let me know in the Q&A. It's an interesting phenomenon as well. Finally, moving on to the UK context. So here, what we've observed is essentially a process in which first the issue of legislating these asylum seekers through the Rwanda bill, which is only one bill in that context, how this has been first reviewed by British courts. And in that context, the most recent development is a decision by the UK Supreme Court a few months ago that essentially agrees with the European Court of Human Rights judgment a few months earlier that Rwanda is not yet a safe country. So asylum seekers cannot be sent to Rwanda. There's a risk that, again, risk of, with respect to non-refoulement, that they might be sent back to their countries of origin and running the risk of basic human rights violation. So this is essentially an empirical question. It's not a legal question. It's really whether the Rwanda asylum framework is fulfilling some conditions. There's an interesting interplay between British courts and the European Court of Human Rights. The decision that I've listed here with respect to the European Court of Human Rights is not a final judgment of the court. It's what we call an interim measure. So an interim measure is this tool that both European courts have at their disposal when they have to intervene very quickly to prevent some serious human rights breaches. And so the European Court of Human Rights used that procedure with respect to asylum seekers. And then these decisions had to be taken into account by British courts. So you see more of an alignment today. And again, that shows that courts in the UK are still very much independent and effective at resisting these populist waves. But this is yet to be observed because this is very much a phenomenon in motion. The most recent version of the bill is currently under review by the House of Lords in the UK, and they haven't finished that process of review, so we have to see what happened. But again, this is, I think, a qualitatively different phenomenon compared to Hungary and Poland. Much more specific, much more circumscribed, and with the UK judicial system still very much operating under the rule of law. Okay, so coming to conclusions. So I know that I've talked a lot and I've covered quite different things. So the conclusions are, I would say, perhaps still tentative in the sense that something that I've said can be observed over the course of 10 to 15 years. Other things with respect to UK happened just very recently. But still, if we wanted to have a very broad kind of snapshot of what had happened, again, I think that what's distinctive about the erosion of the rule of law in Europe is of a structural nature, not of a coercive or individualistic nature. I think that's a very interesting phenomenon. So we have governments that are using law and legislative procedures to enact some policy that clearly are in breach of rule of law or human rights standards. So it's some concepts have very much emphasized that, such as autocratic legalism, for example, right? So, and that's a concept by Shapley, if you want to look at it. If we want to go back to the concept of the rule of law, so I've tried to give you some ideas with respect to a constitutional theory and democratic theory. But if we want to stick with the rule of law, I think that the best account, or the account that is the most helpful, is probably the one of Jeremy Waldron, which basically defends a procedural account of the rule of law that emphasizes typically issues such as judicial independence and due process rights. And I think that concept is particularly relevant. Yeah, that might be the aspect of the rule of law that is particularly attacked in Europe these days. But as I've suggested, and this is very much my kind of contribution that I'm trying to make in this area of research, I think we need democratic theory and studies of populism to better understand the roots of the phenomenon. So the rule of law might be very helpful to observe and to qualify what's been happening on the surface. But I think that if you want to go back to the roots of the problem, I think democracy and democratic theory can be very, very helpful. And finally, one word about European courts. It's very important to keep in mind that these courts have a limited jurisdictional reach. The Court of Justice of the EU is the widest jurisdiction. The European Court of Human Rights is not a constitutional court. It is a human rights court. So it has limited jurisdiction, again, in tackling the kind of structural dimension of the problem currently. And one question that we can ask is, as we saw with the Court of Justice of the EU, is that it has the power of the sword, but it also it also has power over the purse with its financial penalties that we can impose. The European Court of Human Rights doesn't have that power. So we have to keep that in mind in crafting the kind of responses that these courts, that we might want these courts to offer. Okay, so a few references for you here if you're interested in the sources that I've used. Just to finish on one word from myself in terms of my visit here, I'm very keen to meet colleagues here and students. If you're interested in European courts, I'm also very much interested in what's happening here. So I'm available until the end of the month. And I look forward to your questions and comments. Thank you so much.